Chapter 11 is over civil liberties and civil rights. What is a civil liberty? Civil liberty is individual rights and freedoms that are guaranteed by the federal government. So they are installed by a higher power, not by government. In order to keep a lawless society, we grant governments the ability to secure peace and self-preservation. What does that mean? We know that we have to be governed by our government to provide us with safety and peace, that we have laws and rules that we must abide by. That is what keeps us from being and becoming a lawless society. Civil liberties cannot be violated. They are free from dictation by the government or anyone else as to what you do. When violations occur, that's when our court system gets involved to resolve those disputes. So a civil liberty is an individual right and freedom that are guaranteed by our federal government, and they cannot be violated. The Bill of Rights are the first 10 amendments to the Constitution, which was passed by our first Congress in 1789, went on to be ratified in 1791. So you have the first 10 amendments, and we'll go through each one of them a little bit later. So you can look at those in your book as well. Incorporation doctrine after the Civil War. Wait a minute, let me go back. No. After the Civil War, the Bill of Rights was still not accepted by all of the states. The 14th Amendment was the problem. If states adopted the Bill of Rights, then the slaves would need to be freed. And they didn't want that to happen. They did not want to free the slaves. So the case was still, it was still not completely ratified because of the 14th Amendment. By the time 1920 rolled around, there had been several cases that were seen in front of the Supreme Court, which basically resulted in most of the Bill of Rights being applied by all the states. So your First Amendment rights, the First Amendment is the freedom of speech. Government cannot regulate what or how you think. However, what you say can be regulated. Okay, that's the difference. In the act called the Alien and Sedition Act of 1798, it made it illegal for people to publish anti-government writings, anti-government speech. In 1919, if you created a clear and present danger, that was against the law. Obscenity and pornography. There's one case, Chaplinsky versus New Hampshire of 1942, was around obscenity and lewdness, and decided that those and fighting words are not protected by the First Amendment. The Supreme Court in recent time has been very strict on child pornography cases. So those are a couple of things that are with your First Amendment. First Amendment around the freedom of religion. The colonists, when they came, did not want to establish religion for the colonies. They didn't want to do that. So something was called the Establishment Clause. Congress would not establish a state-sponsored religion. I'm going to repeat that because we find ourselves in a time where some in government think they can tell people who or what to serve on a religious level. The Establishment Clause makes it real clear that Congress would not establish a state-sponsored religion. There should be separation of church and state. And that is called into question lately, especially with the most recent ruling out of the Supreme Court as it related to what Governor Cuomo was trying to do in New York in terms of limiting the gathering of people at church services. And the Supreme Court said, no, he couldn't do that, although he's really trying to avoid another health crisis in his state. But we'll see what happens. Free exercise clause. Government cannot prohibit people from exercising their own religion. So you do not necessarily have to go to a church to exercise your religion. The idea that prayer was taken out of schools, I find to be problematic because I have never needed anyone to tell me to pray. If I so needed to pray before I took that exam, I did so. Now, whether anybody heard me, that wasn't what I was praying for, because whomever I was praying to heard me, if that makes any sense. So, free exercise clause, government cannot prohibit people from exercising their own religion, and their own religion could be none. Second Amendment, the one that gets everybody up in arms, the right to bear arms, right to protect. And so most people agree that there should be some sort of gun control. Not to take anyone's guns away, but limit what type of weapons one can have without going through the proper background and procedure. In 1993, the Brady Bill was enacted, and that was to provide for a 5-day waiting period on handguns. For all that people talk about the 1994 crime bill, they leave out the fact that it was in the 1994 crime bill that it banned 19 semi-automatic weapons. Unfortunately, the ban on those weapons expired under George W. Bush, and he had the ability to reinstate it and chose not to. So if you were to do a study of the number of school shootings or mass shootings that have occurred since the ending of the ban on semi-automatic weapons, I think you'd see why that probably should be back instated. Fourth Amendment, due process, search and seizure. What does that mean? That police can search your car under certain circumstances. If they pull you over and you have paraphernalia in the front seat of your car, that's an automatic way to be searched. If you're under arrest, they can search. So there's a warrant. They have to read you your rights, and that'll come up in a little bit as well. Fifth Amendment, the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford one will be afforded to you. So do not say anything. You have a right to remain silent. I suggest if you're ever pulled over or if you're ever read your Miranda rights, remain silent until you get an attorney present with you. So that's the Fifth Amendment on self-incrimination. The Sixth Amendment, the right to counsel. Everybody has a right to counsel. Eighth Amendment, cruel and unusual punishment. NAACP back in the 1960s decided that that they felt as though the death penalty was cruel and unusual punishment. We have a current administration right now who is in the process of executing more people on federal crime that has happened in probably 50 years. And they're doing it at a rapid rate of speed. For a president and an administration to be what's known as a lame duck, they will execute before he leaves office, I want to say, another 10 people between now and then. That's a lot. So the death penalty is always one of those that, people, is another one that people are passionate about. Either you're for it or you're against it. And then if you're against it, you create all these reasons that don't necessarily have anything to do with it. And if you're for it, you create a whole bunch of reasons because they shouldn't have done what they did and everything. But you're the same people that value life and are against abortion. So it's kind of interesting how that plays itself out. Public privacy rights. You should note that abortion rights was about privacy. It was never about right to life or not to have a child. It was about a woman's right not to have to tell her husband. So abortion rights was just Roe versus Wade. Granted, a 24-hour waiting period and parental consent was needed, but it fell under privacy. Abortion rights, the Roe v. Wade case, fell under public privacy rights. I bet you didn't know that. Homosexuality was another big thing that falls under public and privacy rights. Whereas in the state of Georgia, a case called Bowers versus Hardwick, that it ruled in favor of the state outlawing hetero and homosexual oral and anal sex in Georgia. So if you were in Georgia, you were not allowed to participate. Another public privacy right is the right to die. Supreme Court case of 1997, terminally ill people cannot commit suicide. 61%, and this was several years ago, of the public believe that doctors should be able to assist in suicide. And that means primarily in the event a case of a person who is terminal. There's no viable option for them to get better. And they make the decision that they would prefer to just go, as opposed to go through the pain and treatment and spending all this money on something that is not going to benefit them. They want to have the right to die. And that's what that one is about.